Greetings, my name is Patrick Phancao with the Asset Protection Center. I am an estate planning attorney focused in the field of asset protection and elder law out in the state of California and Florida. Today, let's study the important component of timing when you do an asset protection plan. Let's first ask, when is the best time in order to undertake asset protection? Well, the answer is simple. It's before any lawsuit or any claim arises against you. Why? Because the law allows you and enables you to do planning for what is called a rainy day. And in reality, what you want to keep in mind always with planning for asset protection is that you want it to be complementary to an overall estate planning objective, such as minimizing your estate taxes and so forth. So what happens if you start to do some asset protection planning after a lawsuit or a claim arises, where you're basically looking at two different situations. One, with reserves. So let's say that you have $1 million in asset and someone comes after you for $200,000. Well, you're completely allowed to extract $800,000 out of your assets and basically set it aside and protect it from a lawsuit. This is called the no harm, no foul rule, so to speak, because there is sufficient assets to satisfy the claim. And then the second situation is basically with no reserves. This is when you choose to basically strip yourself from any equity from your belongings. And that's a rather dangerous approach, one I would definitely not recommend. Why is that? Because you would be entering into what is called a fraudulent transfer. Fraudulent transfer is a term of art that basically claims an assertion against the debtor. The debtor is the person that owes the money, where that person undertakes some asset protection when he or she knows there is a present creditor, an individual coming after them for a specified amount. So, if you do that and you have the intent to hinder, delay, or defraud the creditor, you would be clearly in the fraudulent transfer universe. Now, when you have the specific intent to bypass that lawsuit, it's easy to claim a fraudulent transfer, and that's basically when you enter what people call a natural intent to defraud. The truth is, in all my years, most people don't go ahead and volunteer the specific intent of, oh yes, I really did want to bypass this lawsuit and I had the actual intent to defraud this creditor. So what the law has created is called the badges of fraud, which is basically a test with a series of elements, and upon meeting some of those elements, they will be able to determine that you did indeed have the intent to defraud the creditor. So hopefully that was a helpful piece of information. If you want to find out more about this, go ahead and visit me at www.assetprotectioncenter.com or call me at 714-966-2646, and I'll be happy to talk about your situation. Thank you for watching, and I will see you next time.